given to him, Frank?
Yes, sir.
Who's, does the defense have that?
Yes.
Okay. Can you make a copy of that?
Oh, it's a copy. That's your copy.
Okay, thanks.
I gave him a copy.
That's all, that's for Willie's, that goes in the Willie's file. That's a copy for us, so we're okay.
Oh,
I just need to put it
You have the
aside.
file still, I think. You still have one file, you still have.
I got. Nice.
You want these copies too? That I gave you?
Everything, I'm gonna put it together, so. Yeah. Thank you. Gary Falk? That's you, sir? 23 CR 1750 is called. And there is a motion to revoke probation that was filed October 2nd of last year. You were here with Ms. Naldi, your attorney and the state's attorney. Does the defendant waive a formal reading of this motion to revoke probation? Can we proceed in summons? Raise your right hand, sir. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. In summary, this motion states that on May 16th of 2024 in this court, you were sentenced to 18 months in the state jail. That was suspended for 5 years for evading arrest or detention, a state jail felony. But let's see, there must be prior convictions. Okay. State jail felony, it's punished as a third-degree felony, correct?
No, sir.
No.
This is state jail. This is
18 months.
previous convictions makes it a felony. So he
Okay.
was running on foot. He wasn't with cars. So no.
Okay, because it's got a true on the priors. There was
Because he was sentenced to 18 months, so they sentenced it as state jail.
3, 4 priors. So we didn't go on those third degrees.
No,
It's
sir.
just,
Enhance it to make it a state jail felony. Should
could
be.
have been though.
It could have been.
Could have been.
That's correct, but
Yes,
it's
sir.
not.
Could have been up to up to 20 years in prison as a potential. We there's a lot of leniency given here. All right, so is all of that true so far? You were sentenced to 18 months in state jail, and that was suspended for 5 years on May 16th, 24. Correct? All right. Allegation 1 states you failed to report to the probation office for May 5th, June 9th, July 10th, July 17th, July 30th, all 2025. Is all of that true?
Yes, sir.
And was he an absconder?
Yes, sir.
How long?
He was gone until he turned himself in.
Which was when?
December.
Okay, so from May to December, you never reported to the probation office, right?
Yes, sir.
May of 2025.
May 5th of 2025 to
December
through December.
He did come in June 23rd and met with me, and then he was gone after that. He came in after I called him, and he did come in that one day, and after that, he was gone. So there was a June 23rd.
You gotta report or you're not on probation.
I couldn't make it to the appointment. I came in and told my PO she wanted to change my location, but I was in Beaumont and had to come to Port Orton.
Okay,
Yes, sir. And I let my PO know that I didn't have no reliable transportation.
we gotta figure it out.
I was in the process of moving, so I turned myself in.
When?
December.
6 months later.
So,
What happened in those 6 months?
I was in Beaumont.
Half a year.
I was in Beaumont and
You were on your own probation.
when I was homeless.
You gotta figure it out, sir. If you're either on probation or not, but we accommodate people when they know. The probation office is very accommodating. We have a great success record. You're 1 out of 14 who fail. You're 1 out of 14. 13 out of 14 are successful. That's a great record. Allegation 3 states you provided a urine sample on April 14th of last year, which showed the presence of tetrahydrocannabinol, marijuana, and cocaine. Is that true?
Yes, sir.
Can you explain that?
I was drug judge, and I take medication.
Cocaine? Who's giving you the cocaine? Which doctor is that?
And health medication. And I just-
Well, you know that's wrong. You know it's illegal. And
So,
all right, are you pleading through then allegations 1 and 3 voluntarily and because those allegations are true?
yes, sir.
Do you understand that a plea of true, voluntarily and knowingly made plea of true to one or more violations of probation, that is enough to grant a motion to revoke probation? Your probation can be revoked and you can be sentenced to no less than 180 days up to 18 months
Yes, sir.
in the state jail. Knowing that, do you insist on pleading true to that?
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. Do you have a calculation of this? What time you last credit? How much time have you served in this case? Do you know?
December 28th.
No, before that. When you were arrested and waiting,
Yes, sir.
being put on probation, were you in jail a while?
Yeah, like a month.
Okay. Okay. Okay, thank you. I'm looking at the pre-sentence report where
That's why I give it to you.
Yeah.
oh, 3 full pages.
Don't look at me like that, Judge.
Huh?
Don't look at me like that.
Your criminal history dates back to 1988, so that's 38 years.
28, 1998.
Today's 26, 88. 12 plus 26 is,
I thought you said 98,
I'm gonna give you
because you were aging
would you
me.
like an abacus to
No, but if it was 98, then you were aging me 10
88.
years, and that's not.
88
Okay.
to
88.
26, which is 38.
38.
And that's well, you have to look at the whole book here, not just a few chapters. You have as a juvenile, there were 30 some odd dispositions. Most of these were runaways and other things. Yes. Your home life must not have been a solid one, huh? No. And then we start with adulthood, and you've got how many convictions of misdemeanors and felonies do you have as an adult? I see 2 misdemeanors of evading detention and assault of bodily injury of a family member when as misdemeanors. But what about felonies? Because there were several, more than one case where you were placed on probation and then your probation was revoked and you were convicted. And then later on, subsequent to that, there are some robbery convictions, aggravated robbery convictions. So how many felonies do you have?
Maybe like 4 or 5.
They're 5. Okay. So we place you on probation here for evading arrest or detention. And he's pleaded true. There's no agreement here, right?
No, Judge,
Okay.
the office for 18 months, which is the most that he could get.
Cap of 18 months.
Um,
Well, that was.
That's what he
when
could
was
get.
put on
Yeah.
probation originally, right?
right.
So you're looking at no less than 180 days up to 18 months in the state jail. State, you want to go first and last?
Judge, I would ask for 18 months. Speaking with probation, it's either the 18 months or they're willing to still work with him if he's willing to go to SAFPF. If there's a problem there and he could go and complete SAFPF and come back and be on probation.
That's right. That's
Yes, sir.
And that's what I have spoken to Mr. Falk about, and he is interested in taking advantage of that SAFPF option.
No,
and
I'm
clear.
not talking about the interest. I mean, would you do it?
Yeah, he's willing to do it. He's motivated to do it.
Yeah. Is that
Yes, sir.
the nice lady speaking for you? But I want to hear from you. Is that what you want? It helps. It helps people.
Yes,
but-
sir. I go to program.
But you've got some problems here for a long time that you haven't resolved. And this could help. But you've got to put in an effort. Are you willing to do that?
Yes, sir.
Okay, so I'm going to find that there is sufficient evidence supporting this motion to grant it by a preponderance of the evidence or greater as allegations 1 and 3 are proven true. I'm going to hold this motion, I think, in abeyance is the way to do this. We are going to modify a term and condition of probation to require you to attend and successfully complete the substance abuse felony punishment facility program. Do you understand where we are on this? You gotta do the heavy lifting. You gotta avoid the drugs. But it's obvious your home life was a wreck growing up. I mean, it's obvious. I've seldom have I ever seen a child with that many dispositions, and it must have been a difficult family household, I presume. But you're an adult. You got to handle your responsibilities. Fix this so that you can move on the best you can. Are you promising to do your best?
Yes, sir.
Okay, do it. All right. We'll continue on your probation and complete that substance abuse program. All right, and do well. Thank you.
Thank you,
Vicky Holloman. Vicky Holloman. Where's Vicky?
She's in a wheelchair, Judge. It might take her a second.
Miss Holloman, come on out.
She's a plea.
Thank you.
You have to use this approach to insurance, right? And I'm working on this code. That has the other pen that might do that.
Okay. Vicky Holloman, please.
We'll need her thumbprint.
You're next. Thanks. Who do you have? Thank you.
And then some homes, others of them, I was asked if that, she didn't look like that, so. Okay.
I'm gonna do one term, the next winter.
Mm.
You can leave that.
What's it different?
Right there. Oh, that was too late. You want next to it, don't go over
We've already spoken to the nurse. She's okay with this. With the help of the defendant, and she knows her from previous contacts at the hospital.
This was at the hospital.
Yes, sir.
Thank you. And we now call the state of Texas versus Vicky Holloman. That is you.
Yeah.
present with Ms. Mouthy, your attorney and the state's attorney. Does the defendant waive a formal reading of this indictment and arraignment? Can we proceed in summary?
Yes, Judge.
In summary, this indictment alleges that on or about October 1st, 2024, in Jefferson County, Texas, you committed the third-degree felony of assault on EMS personnel, emergency services personnel, by causing a bodily injury to that person by striking them in the chest with your hand. Do you understand what you're charged with in this indictment?
Yes.
An agreement's been reached where you would be pleading guilty to the lesser included offense of Class A misdemeanor assault, which carries with it up to 1 year in the county jail and or a fine up to $4,000. Do you understand the punishment range applicable there?
Remember how we went over the punishment range? He's asking you if you understand the punishment range for the Class A.
Yes.
Okay.
An agreement has been reached where you would be sentenced to 10 days in the county jail. Is that right?
Yes, Your Honor.
Judge.
Okay,
She gets credit for that, so it's a time served resolution.
okay. Just help me out on this,
Yes, sir.
because this court is sensitive about public servants, people who help, like emergency medical people, law enforcement, those folks who are public servants. Part of their job is not to be assaulted by the public. They're answerable to the public, but they're not to be assaulted. I understand this as a plan. Is there any reason why, like, probation wasn't considered on this? Because we open the door.
Judge,
This is a, these are, I mean, she's indicted for, you were looking at actually up to 10 years imprisonment by the grand jury's indictment. That's serious. But what are the circumstances that caused this one to be minimized?
Judge, mainly, there are two things. One is her health was a consideration in this, and also speaking to the nurse. The nurse also is familiar with her and knows how many times she's been to the emergency room with her health conditions. She's been released from the jail. Every time we put her in jail, they release her on a personal recognizance bond for medical reasons. And so after looking at all that and talking to the nurse, she's okay with the Class A misdemeanor. And so
What happens the next time if she assaults somebody next time? What? I'm sorry, it happened once. It can always happen again, man.
And Judge, this is her one opportunity to correct that behavior. If she doesn't, then we'll come back and we'll prosecute her for the third-degree felony. But there wasn't any bruising or anything on the nurse. It was just it was a strike. But I understand, Judge.
You know, and people can say, but I didn't bruise any. But I assaulted. I want the Vicky Holloman rule.
And our office takes this serious, and so that's why we called the nurse before we did this to make sure she was okay with it. I wouldn't have done it otherwise.
And there were a lot of hoops to jump through to get to this point. There's been a lot of discussion between Mike and I and Mike and his office to try to figure out a resolution.
Well, there ought to be a lot of discussions on it because resolving something fairly is the right way to do it. But once again, we set standards
Yes, sir.
of how things are going to be. That's what's fair. People go, well, that happened there. I get the same deal.
I guess my point is this wasn't done lightly. This offer wasn't done lightly and wasn't done without consideration.
Every circumstance is unique. That's a fact. Some are so close that it's hard for people to understand a distinction.
Yes, sir.
And what about you, Ms. Holloman? I want to know, what do you say about this? Do you regret what you've done?
Yes, I do.
Do you understand what you've done?
Yes, sir.
Is it going to happen again?
No, sir.
I've had those promises before, and people come right back.
Not for me.
If I follow this agreement of 10 days in the county jail on this Class A misdemeanor, you have no right of appeal of your case. Do you understand? What's a yes or no, helper?
Do you
This-
understand you have no right to appeal? The decision in this case will be final?
Yes.
Yes.
Again, how do you plead? Are you guilty of this assault? And you're pleading guilty voluntarily? And because you are guilty.
Yeah.
I'm going to show you what's marked as State's Exhibit 1. Caught a fish there. Did you sign that? Voluntarily understand it, discuss it with your attorney. Is everything true and correct?
Yeah.
State's Exhibit 1 is tendered into evidence. Without objection, it's submitted. This states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses such as this assault. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yeah.
States Exhibit 1, part of the record for all purposes. Pre-sentence report waived.
Yes, Judge.
I will follow this agreement if nothing further, and I find you are mentally competent to enter this guilty plea, freely and voluntarily made. There's enough evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this lesser included Class A misdemeanor of assault. And following this agreement, you are hereby sentenced to confinement in the county jail for 10 days, and you will be given credit for time applicable to them. Anything else?
No.
That is all. Thank you. I've got I'm going to jump ahead here on Mr. Sanders' cases. I've got Ryan Anderson. Ryan Anderson.
You have to file.
I've got it. And then also, I'm sorry. You were Terry Williams in 25 CR 28. This, do you need to do anything with him? He's about to enter the plea.
If would like to file, just go sit down.
Yes, Rose.
Right. They should buy some. They're just straight up and down. I think what we're gonna do is see one time that maybe somebody. Just straight up and down, you can have them like that. Straight up and down.
That lawyer in the back, he's selling Girl Scout cookies.
Do you?
Yes, ma'am.
What do you like?
Shortbread's losing, but I already bought a bunch from it. Actually, it was from his daughter. But he works for his daughter and sells those. Yeah, I'm a shortbread cookie person. All right, 25 CR 28 is now called the State of Texas versus Terry Williams. That's you, sir. Present with Ms. Manal, your attorney and the state's attorney. Does the defendant waive a formal reading of this indictment and arraignment? Can we proceed in summary?
Yes, Judge.
In summary, this indictment alleges that on or about December 6, 2024 in Jefferson County, Texas, you committed a third-degree felony of obstruction or retaliation. Do you understand what you're charged with here, sir?
Yes, sir.
This is a third-degree felony, which means if convicted, you face no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
An agreement has been reached in your case that you would be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length, fined $500. There will be terms and conditions of probation, which are normal and customary. If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this, sir? Guilty or not guilty?
Yes, sir.
Are you pleading guilty voluntarily? That is on your own free will,
Yes,
and
sir.
because you are guilty of what this alleges. I'm sorry, I spoke. Okay. I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
States Exhibit 1, part of the record for all purposes. Pre-sentence report is waived here.
Yes, Judge.
There's a recommendation of 5 years. What do y'all say? Before we start writing on the thing. I generally,
think where he had a 7-year deferred probation, but that was back in the 90s.
would you,
He
if
did,
you
he
successfully,
did complete it, but
if you are successful on probation, I can shorten this to 1/3, 3 1/3 years on 10 years, which is even better than 5.
yes, sir.
But it's up to you to decide
Yes, sir.
whether you're going to complete it well or not.
I will. Yes, sir. I'm working.
Everybody says it. In
No,
fact, everybody signs a document that says, I'm going to follow them, but they still come up here.
Volunteer work at Lakeside Center. I do in Liberia. I do volunteer work there too. But I'm not protecting. I'm not no bad person.
All right.
I'm a workaholic.
If nothing further, I'm going to find that, again, you are eligible, for a deferred or unadjudicated probation here, and I'm going to set this at 10 years with the asterisk, you do well, and we'll shorten it to 1/3. You must serve, you're going to complete an anger management program. There will be a fine of $500 and other terms and conditions of probation that the probation officer here, a nice man, is going to go over all of these. Make sure you follow these. If you fail, your probation can be revoked. You can then be found guilty and sentenced up to 10 years in prison.
Sir.
Good luck. Thank you.
Deferred judges.
Yeah, it's deferred or unadjudicated.
Joe, you gotta get your signature on this last.
Yeah.
And thank you, sir. Cornelius Beard, that's a review. Okay. You're Mr. Beard?
Yes, sir.
Okay. And Mr. Perry is here from probation. There is a motion to revoke unadjudicated probation that was filed years ago, about going on 3 years ago. You pleaded true to failing to provide verification of performing community service hours. And what we did is we held the MTRP, the motion to revoke probation, in abeyance and continued you on probation. And so you are on probation for 10 years for aggravated assault, family violence from June 17th, 2013. So you have passed by that 10 years, and this motion to revoke probation told or put it into a suspended animation, and then we're trying to get to the finish line. So, Mr. Perry, where are we?
Your Honor, since we last met in November, he has paid $235 toward, of course, his fees. I mean, there's some statement, he was placed on inactive probation.
Yeah, I think he's on inactive.
Yeah.
So what are we doing today?
We'll just give an update on his payments.
What else does he need to do to complete and finish this,
Just keep paying consistently.
sir?
Keep paying at least up to $200 per month.
Okay, how far behind is he? He doesn't have restitution, right?
Correct. No
So
restitution.
what are we talking about? How much is still left to be paid?
They have a balance of supervision fees is $859.
$859? That's it?
Yeah, it's going up to supervision.
That's it. That's it. So if he found $859, for instance, today, then we would dismiss this case.
Yes, Your Honor.
It would be then dismissed.
Yes.
Okay. That gives you a goal line to
Yes, sir.
go after him. What do you think? How long would it take you to get to that? Or his fees still adding up, or
It was
they,
just supervision because everything has been suspended.
everything else is told is stopped.
Yes.
So you're at 849. When can you get that paid?
No, I work, but
You don't have.
I don't have $849.
Yes, sir.
Cash.
What do you think?
What
What?
do you get income tax?
Yes, sir. How much are you making it worth?
$17.99 an hour.
Okay, that's 18. That's okay. That's about 40 grand a year if it's full time.
Yes, sir.
Okay. Well, that's the finish line is right there. Okay. Yeah, I want to whatever we can close off so he doesn't have anything adding up. But we still have to pay probation fees. So that adds up every month. What's that? 60? That's just the way it is.
Yeah. He may last.
So if you don't pay 60, then you start losing ground from the 800 and some odd that you have left. Okay. Any ideas, everybody?
What is that?
Yes, we paying 7. That's paying $10 extra. That's helping out. Is he paying
I've been on probation for 13 years. What do we do? What are my options? It's easy if he comes up and pays the money off. Then all things being the same, as long as you're not in trouble with any other reason, if I sign that thing fast.
Yes, sir.
Look, why don't we have him back in a couple of months and just see where things are? See how close we are. Okay.
Yes, sure.
Is that good? Okay. Thank you, Mr. Beard.
No, thank you, sir.
Yes, sir.